Thanks so much, everybody, for joining us for our next GoAERO expert lecture. It's my pleasure to introduce Gwen Leiter, CEO of GoAERO.
Thank you, Nidhi, and happy and healthy New Year to everyone. We are thrilled that you are joining us for this lecture in 2025. I am very pleased to be able to introduce you all to Ken Zinghini. Ken is a partner in the Business and Corporate Practice Group at Martin LLP. And for over 30 years, he has been a trusted legal and business advisor to companies and their owners, counseling them throughout the life cycle of their businesses on a variety of complex and day-to-day legal issues, including forming and financing, operating, growing, investing in, and selling businesses. Ken understands that the client's business is one of the most important parts of their life, and he takes pride in partnering with them and giving his full attention to their success. Today, Ken will be lecturing for us on ways to start, finance, and operate a new business. So without any further commentary, Ken, take it away. We look forward to your discussion.
Thank you so much, Gwen and Nidhi. I appreciate it. I'm very happy to be here and happy to hopefully share some thoughts with you on the whole process of starting a business and getting it off the ground and financing it and all that sort of thing. As Gwen said, I'm a corporate lawyer, and what that means to me and to us in the corporate world is I handle the corporate matters that Gwen described. I'm not an expert in intellectual property or taxes, or I don't go to court, things like that. But hopefully, I've gained enough experience over the years to be able to speak a little bit about those areas, particularly the ones that'll be most important to you folks, like intellectual property, and to identify issues and at least to know what I don't know and when it's appropriate to grab another expert in that field to help out. So I'm going to talk about the process of starting and organizing and financing a business. As you can imagine, this can get fairly complicated. So I'm going to keep my comments at a relatively high level, and I'm going to move on here, and then you'll see a disclaimer at the bottom, and it's one of those things us lawyers do, is we have to tell you that what I'm going to tell you is not legal advice. There's no client relationship, and this is sort of general information. You obviously need to talk to an expert about your particular situation as things come up. So let's move right into the substance here. First thing people want to know when they're organizing a business is, what type of entity should I use for my business? Where should I organize it? What are the basics? So, there are a whole variety of different types of organizational structures that people use for businesses. I've listed, the most popular ones here: sole proprietorship, general partner, corporation, limited liability company, and limited partnership. Those are the most popular ones. There's some other things out there, but what you're most interested in when you're starting a business, like that you folks would be interested in, is you want limited liability. What does that mean? So if you start a business and run it as a sole proprietorship or as a general partnership, the individual owners have liability for everything that the business does. So if there's a lease, you're on the hook. If there's a lawsuit, you're on the hook. So you're looking for limited liability, and the types of entities you're looking for are corporation or limited liability company. I've listed limited partnership here too, but that's not really a form of business structure that people use for operating businesses too often. So you're all gonna be interested in what is a corporation, what's a limited liability company, how do I set them up, what are the differences, what should I be thinking about? So first off, most importantly, both LLCs, limited liability companies, and corporations offer what's called limited liability for their owners. And that means, assuming you do things the right way, as an owner, you're not liable for the liabilities or obligations of the business. You're not personally liable. So if you sign a contract in the name of the corporation and something goes sideways, the party on the other side has a claim against the corporation or the LLC, not against you personally. There are certainly exceptions to that, but that's generally what you want. You certainly don't want personal liability for all those things, especially as you grow your business. You will, note, for example, that as a small business owner, some counterparties like landlords and others may ask you for a personal guarantee. In that case, you would be liable personally for that particular obligation. And these are things, you can negotiate and you have to work out on an individualized basis. And as you get more, larger and more substantial, those things will go away and you'll just start, the business will be the sole obligor of all those types of obligations. So I mentioned corporation and limited liability company being the most, common structures for business ownership. What are the difference? How do you decide? Well, as I said, both offer limited liability. They're both well-known and accepted structures, but they have differences. LLCs tend to be much more flexible legally and in terms of, how you manage the business. They offer pass-through taxation, which means you get taxed personally, but not by the entity doesn't pay its own taxes. And there's a lot less formalities to follow. Corporation, on the other hand, has some stricter requirements, a lot more formalities around setting up and operating a corporation. There's also the potential for double taxation, which you may have heard that term, where when the corporations pay their own taxes, then if they dividend profits out to their shareholders, those dividends also are subject to taxation. So that can be an issue. Typically not an issue for early startup companies because you're not running at a profit anyhow. But that is a feature of corporations that is really relevant as you get larger. But corporations are also, on the positive side, are often preferred by institutional investors such as venture capitalists. So if you manage to grow your business to the point where you're going out to venture capitalists or other institutions or professional investors, a lot of them may not only prefer, or they may even require that your business be set up as a corporation. So there's a variety of, considerations as you set up your business as to what type of entity you'll use. And you really need to look at where your business is, what your plans are, and let that all, discuss it with whether it's your accountant or legal advisors, let those types of things decide, how you'll set it up. The other thing is, there are ways to change. If you set up as an LLC and it turns out down the road that you're getting into a place where you think you need to convert to a corporation, that can be done for, it's run by, state law in the state in which you're incorporated or in which your organization has been formed. But there are some risks and complications and things you'd have to deal with at the time. But just conceptually, if you organize as an LLC, you can convert to a corporation down the road if that's required. Doing the opposite tends to be much more complicated and difficult. If you organize as a Chapter C corporation and you want to convert to an LLC, the tax implications can be much more difficult. So that's just something to bear in mind as you come to these decisions. So if you've decided what entity type you think you need to organize, the next question is, well, where do I do it? And you've all probably heard that Delaware is the place where people set up their businesses. And that is true. It's a very popular state. And as I mentioned briefly, corporations and LLCs are creatures of state law. So each state has its own kind of laws and processes for setting up different types of business entities and how they are kind of managed at a high level amongst the shareholders and the boards and the managers and so forth. So, why is Delaware, so popular and is that something you need to be considering? Sure. The law in Delaware is very well developed. They've kind of set up a system that, wanted to bring in lots of corporations and LLCs to form their businesses there. So that they've set up a court system and a legal system. They operate very efficiently. And Delaware also has some sort of more friendly or less friendly, depending on your point of view, privacy arrangements. In other words, if you set up a corporation or an LLC in Delaware, there's nothing in the public record that indicates, who the owners are and that sort of thing. So there is some privacy element, which some people find valuable. Others are not terribly concerned with that. The negatives are that if you set up your entity in Delaware, but you're operating in New York or California or Texas or anywhere else, you're going to have to qualify that business, that company to do business in whatever state you're operating in. It's not a difficult thing to do, but there's some filings and some annual fees that are involved. So it adds a little more administrative work, by having to really, be doing annual filings and paying some fees in both states. And, that's worth it if your business is going to grow and be successful. If you're just running a small business that's always going to be local, you might be better off organizing in your own home state. And you really, again, have to just look at what you're planning to do and what makes sense. And once again, if you make a choice to organize in your home state and it turns out, based on some financing plans or other reasons going forward that you want to move to Delaware, or you start in Delaware and you want to move someplace else. That's what Tesla did recently. I think we may have all seen that in the news. That can be done too. The term they use is redomestication. So you can move your New York LLC to Delaware. There are a few hoops to jump through, but it's not all that difficult to do. So you've got a business formed. You formed it wherever you did. You're in Delaware or you're in New York. There's a few. The next thing is what I call organizing the business. So creating it is one thing. It's created, under the statute of the state that you started in. So what do you mean by organizing it? Well, you have to have some rules and who's going to own it. So if you look at this slide, first question is who's going to own the business? Who are if it's a corporation, who are the shareholders? If it's an LLC, who are the members? Those are the terms you would use to refer to owners of those businesses. The founders. So if you're the one who organizes it, you're certainly going to be an owner. Maybe there are more than one, maybe not. So that's really it to begin with, but you're going to need some cash going forward probably. So you're going to raise capital, whether you borrow money or issue shares, and we'll get into that in a lot more detail down the road. So those will be some other owners. And if you have employees or consultants, executives that you want to compensate by giving a share of equity, whether it be stock options or other things that we'll talk about, those would be other owners that are involved. So that would be your ownership. And again, a theme throughout this is when you start your business, things can be fairly simple, and hopefully you're going to be successful enough that things are going to get more complicated. So as you grow, things get more complex. So hopefully you can look down the road a little bit and make some decisions, based on where you think the company will be in terms of growth and complexity. But for starters, you have your founders, they own the shares, and down the road, you may have employees and investors. So how's the company managed? And I want to take just a half a second to talk about what I refer to as kind of, the inside management of a business and the outside management. So the outside management of a business is kind of what we all think about as, you have executives that deal with customers and suppliers and regulators and whatever it is, that's your outside. And that's governed by whatever the laws of contracts and other things are. What we deal with when we're talking about organizing a business, and a lot of what we'll talk about today, is kind of what I call the inside management, which is, it's really the relationship between the owners and their managers, which could be the board of directors, the officers, et cetera. Not necessarily employees, because employees are hired, but we're talking about kind of the major corporate folks that are involved. And that's what the corporate statutes deal with, and that's what a lot of, the things that we'll talk about are part of in terms of, investors. That's what the investors care about when they negotiate all these different terms. It's how, what's the relationship among the shareholders and between the shareholders and the managers. So how's a company managed? Typically there's a board of directors or a board of managers. Again, if you're an LLC, you can be more flexible at this. You can have a single manager. That's okay. Corporations have a few more, hoops to jump through. You have to have a board. You have to have at least one director. You have to have certain officers. Like I said, the LLC, you can be, you have a lot fewer formalities to have to deal with. And I'll make one other comment that I could have made earlier. When I talked about limited liability, that's obviously extremely important to a business, and that's the bedrock of why you would operate your business through one of these entities. But in order to get the benefits of that, you have to treat the business and operate the business as a separate entity. It's a separate legal entity. It exists in the law, and you have to treat it and operate it that way. So what I mean by that, you should never be commingling your funds with the company's funds. You should be, contracting in the name of the company and not in the name of yourself. Things like, there are some basic things. And if you're a corporation, there's a few more things that you need to do. You need to have directors. You need to elect directors. Very simple, but you need to do it. You need to have bylaws. So these are things that, you need to have an annual meeting of shareholders. So there's some things that are, they're very ministerial when you're a small private company, but it's important, that you really treat the entity as separate from yourself. It needs to have its own bank accounts. It'll have its own tax returns, all those sorts of things. So you'll have a board, you'll have some officers, who are corporate officers that could be the president, the vice president, the secretary. And then you'll have your executives and employees, there may be overlapping here because your executives, your president is not only an officer of the company, but he's also, or she's also an employee that works for the business. So, and then you may have your consultants and contractors, your 1099 paid contractors. One thing to just note here is a lot of companies will bring on folks and they will treat them as if they're independent contractors and not employees. And that makes sense for the company, and maybe it makes sense for the contractor as well. But there is a sort of trap for the unwary, which is if you have folks working for you and you're treating them as 1099 independent contractors, and you're not withholding taxes and issuing them W-2s, but in fact they're actually doing things and acting as employees, the law may treat them as employees, and you could have a significant tax issue down the road if you're not careful. So I don't want to get into that. It's way too complicated for this, but it is just it's something to be thought about if you're bringing folks on to help you and they're regular employees and you're kind of controlling what they do the same way you would other employees, but you want to treat them as 1099 independent contractors. I would just suggest to be a little careful about that and maybe get some advice so that you're not, getting yourself into a tax problem down the road. The last thing is a lot of small startup companies will have advisory boards. Great to bring on advisors that can, they're not employees of the company. They're not decision makers. They're not officers of the company, but they come on as advisors. Usually pay them a little bit of equity to help out. They may have expertise in the industry or in some way be useful or be able to introduce you to customers or suppliers or sources of capital, things like that. So advisory boards are very handy and something to be considered down the road. So now you've got your company formed, you've kind of organized it, you've got your board of directors and so forth, and your officers. Well, now you need some employees and people to manage the business. So, acquiring talent, obviously extremely important. Some of the things I would, caution about is, you want to have a good package of onboarding documents when you bring on employees to your new business. So if you're starting a business, obviously you've got some plan, some asset. Either it's an idea, could be some technology. There's something underlying that business that you've seen value in, and you're working to build this business to exploit that value. You want to make sure you protect that value. You want it to stay within the company. So typically, when you hire folks, you want to get them to sign some basic paperwork. NDA, which is a confidentiality agreement. You don't want them sharing any of your information. Non-solicitation. You don't want them. You want them to agree contractually if they leave your employment or they stop working for you as a consultant, that they will not hire away your best people, at least for some period of time. They won't take away your customers. They certainly won't talk badly about the company, things like that. Non-compete agreements, very handy, but they're legally challenged. There's been a lot of issues around non-competes, which you may have heard about or not. So, you have to be a little careful if you want to get a non-compete agreement with somebody as to whether it'll be enforceable or not. But it is certainly on the menu of things you might want to consider. And then the last is what's referred to as a PIAA, a Proprietary Information and Inventions Agreement, and that's essentially, that's a document to support the proposition that whatever is made for the company stays in the company. So if somebody's working for you and they're working, they're creating some property or some value, or advancing some technology, that anything they do as they're working for the company owns all rights, and the individual does not. And this maybe sounds, sounds self-evident, but unfortunately it's not. And sometimes there are significant disputes between, those who are working on developing technology or ideas and the company that's paying them to do that. So this is a kind of suite of agreements and things you may want with your employees to make sure you're protecting the company. I mentioned here employment agreements versus offer letters. In employment agreements, you hear that term a lot. They tend to be more favorable for the employee than for the employer. So, it'll really be kind of a negotiation with your senior people as to whether they're looking for an employment agreement and you need to sign some sort of more formal agreement, because that gives them more rights, particularly upon severance, typically. For other employees, you want to give them an offer letter that just generally describes their position and may describe their compensation, and also clearly states that they are an at-will employee. At-will meaning that they can be let go by the company at any time for any reason or no reason, and they can leave the company at any time for any reason or no reason. Obviously, you can't let somebody go or affect their employment for the wrong reasons, like protected classes, based on race or other things that are protected by the law. But generally, ignoring those kinds of situations, most employees are at will. They can be let go because you just don't think it's working out, or you need to shrink your size, whatever it is, and you'd like to retain that relationship with your employees as best you can as an owner-employer. You got to compensate your employees, obviously. Everybody wants cash and benefits. That's kind of basic. But when you're at a startup or an early stage business, you always have, you have a tension, obviously, I'm sort of stating the obvious, a big tension between cash, paying cash and benefits, or paying cash for anything, and issuing equity, which is potentially very valuable and can be awarded to employees or others, service providers, even lawyers, for example, in lieu of cash. And because you're an early stage business, most of them, you're going to, cash is going to be king in terms of helping you, develop your business plan. So you're going to be very careful and mindful about how you spend it. But issuing too much equity in lieu of cash can run into some real problems down the road too. So you kind of always have a push and pull between, how you best compensate people in order to keep them happy, get them motivated, and to manage your own cash situation, but not to give away too much of the store. And we'll get into a little bit more of that later. So cash, yes, there's usually some salary involved, and equity is very common as a piece of employment certainly for senior people, and sometimes especially at a startup, you'll end up issuing equity to a much more significant group of people than just the most senior executives. This could be other employees, again, your 1099 consultants, or could be recipients of equity grants, and your advisors. I mentioned your advisory board. The advisors usually are paid with a small amount of equity in the company. So when I talk about equity, what are we talking about? We're talking about an ownership right. You're giving them some kind of an ownership interest, or an interest that will compensate them as the value of the business grows. So they're getting treated as owners. And how do we do that with employees and other service providers and so forth? There's a bunch of different ways. You can see on this slide, we talk about forms of equity, stock options, stock appreciation rights, restricted stock, and profits interest. So in part, this depends on what form of entity you are. If you're a corporation, you're likely going to issue stock options or stock appreciation rights. If you're a limited liability company, stock options are more problematic, and there is a type of ownership interest called a profits interest, which is much more tax advantage to the employee than issuing a stock option or issuing some equity directly. So the challenge here is always you want to avoid, you want to structure your equity compensation so that the recipient, the employee, doesn't have any current taxable income. That would be a problem for them, right? Because there's no cash, presumably, to pay that. So if you were to, for example, issue stock directly, we call this restricted stock here, you issue stock to an employee as compensation for their employment, that stock will have some value. That value has to go onto their W-2 and they have to pay tax on it. So depending on what that value is, it could be substantial. You don't want that if you can avoid it. So stock options are the answer for that. And that's what's the most common form of equity compensation for corporations. And then, as I mentioned, for LLCs, profits interest is another structure. I won't get into the details, but that's just another way to give somebody an interest in the future value growth of the business. So if you're going to give a stock option, for example, what kind of rights are you going to associate? Is anything go along with that? Well, you could. I don't want to get too deep into this, but you could have an option to purchase, and this is not uncommon, so that the employee has an option to purchase non-voting stock. So that gives them the economic benefit in the future if they ever purchase that stock, but it doesn't, the stock they're owning doesn't come with the right to vote or have any sort of control rights or interests like that. Importantly for the company, you're going to want to have some buyback rights in there, which means that under certain circumstances, presumably, particularly, I mean, if they leave the company, that the company can buy back their stock. Why is that important? Well, as a growing company, you're going to have employees come and go. Hopefully not, but more likely than not, you'll have employees coming and going a lot. That's just the way these things work. And what you really don't want is to have lots of people out there, including folks who have no interest or no relationship to your company anymore, who own a piece of your stock. It gets very complicated and unwieldy to manage, and it's just something that most companies would prefer not to have. So you offer these rights and to employees as they come in. If they stay long enough and they meet all the vesting requirements, they'll actually get the options and the rights to purchase stock, or maybe even stock itself. But if they leave the company, there'll be some kind of an arrangement for the company to take back their stock. And typically, these can go a variety of ways, but typically what you'd see is that if the person leaves the company or is fired for cause, they've done something pretty substantially improper that led to their termination, that you can buy the stock back for little or no cost. On the other hand, if they leave for other reasons, there's usually an option for the company to buy back their stock at some fair value, or possibly a slight discount to fair value. There are a variety of ways, but let's assume you're just buying it back at fair value, which means you'd have to have some kind of evaluation process that goes along with that. So it's just another protection for the company going forward as it grows. And then the other issue is, and this is sort of relates to what we just said, when employees are terminated or they leave the services, whether it's a consultant, an employee, whoever, or an advisor, what occurs then? So you want to protect the company and its other stockholders. So we just talked about there's buyback rights. You want to bring that stock back into the company if you can. And some of the things I mentioned back up top under the first bullet is, you want to have these restrictive covenants. You want to have these non-disclosure agreements and non-solicitation agreements and things. And you may have to or want to negotiate a severance and release arrangement that would kind of be done, on a case-by-case basis, as to whether you need to. I think you want to pay somebody some severance in exchange for getting a full release of the company. So that's just another thing that you typically want when employees are leaving, is you want to have a release that basically has them agreeing that if they have any claims or they think they have any claims against the company, they're waiving those in exchange for getting whatever compensation you're giving them. And, you won't have to worry that there's some claim coming down the road that you weren't aware of. So that's, again, something to keep in mind as people are coming and going from your business. So then, we've got a company, we've got employees, we've got some ways to compensate them, but obviously super important to all companies and especially small startup companies is, where is your cash coming from? Everybody needs cash to run their business. How are you going to get enough cash to pay your bills and pay your people and all that sort of thing? And that typically involves going to third parties for investments. You'll hear a lot of buzz terms and buzzwords around investing and raising capital for startups and smaller high growth businesses. But one size doesn't fit all. There's no single playbook as to how you do this. Again, it goes back to as you grow, you get a little more complicated in your business, and you kind of have to see where you are and what your options are and what your opportunities are, and then make your decisions. So early on, and like most things, as you're smaller, it's less complicated. And as you get bigger and more successful, it gets more complicated. So initially, where are you getting your funding? First place is from the founders, the folks who are starting the business, whether it's one person or a few friends or whatever. Hopefully they have some cash put aside that they're ready to invest in the business, and that'll kind of get you started. And along with that, you may go to friends and family, which is sort of just a catch-all term for people who might be willing at a very early stage to put a little money in this business and take a flyer on what you're trying to get done there. So how do these investments typically work? Founders typically get common stock. Common stock being that kind of the most basic form of stock. It's the bottom of the capital stack, meaning it has the last to get paid if the company liquidates, but it also gets all the upside once everyone else is paid, so it has the most upside. And that's typically what the founders have. That's what your investors are going to want. They want to know you have all the skin in the game possible. So you're typically going to have common equity. It's not totally unusual for founders to loan money to the business as well. But sometimes when you get into, if that happens, you get into later rounds of financing. Your investors may look at that and say, hey, we don't like the company owing money back to its founders. We think that should be converted to stock as well. So those are down the road kinds of discussions and issues that you may have to deal with. But founders, common equity. And now you're in the early stage, and how do you raise money from others? There's a variety of techniques. The most common these days is what's called SAFE. SAFE is a simple agreement for future equity, and it's become a very popular form of funding companies in their very early stages. It's very simple. There are no special rights granted. A SAFE is you're not actually selling stock or other equity in your business, you're entering into a contract with someone that says, if, in effect, if we do a financing round in the future, so we move down the road and we actually go out to raise money from third parties through issuing stock, that your SAFE agreement will automatically convert into whatever that equity is we're selling in that equity raising transaction, and it'll get valued at a discount. So you'll have a little discount rate to usually around 20% to what the investors are paying in the first significant investor round. So safes. The other advantages, safes are, as I said, it's a contract, not an equity security. There's a form of contract that is used by almost everybody. It doesn't vary very much. The only really negotiated points are the discount and what's called the valuation cap, which exists in some safes, which I won't get into. It's a little beyond what we need to talk about here. But otherwise, the legalese and so forth is really well set. People don't negotiate it. There are no special rights for the investors. It's just a contract to participate in the future financing of the company at a discount to what the other investors are going to pay. So, like I said, it's a real easy way to from an administrative standpoint, it's a very easy way to raise funds. Some people, before safes came around, convertible notes were very common. They're still out there. Basically, it's the loan to the company that automatically converts into equity in the next financing round at the same terms, or usually at a discount to what the new investors are paying. It's also quite simple, but it's a little more paperwork. It's a little less plug and play than the safes have become. So, people tend to like the safes more, but there are some other options out there, and some investors may prefer the convertible note route because it actually gives them a debt from the company that they could get repaid someday. As a practical matter, that's probably not really something they need to think too hard about, because if you don't ever have a future financing transaction because the company's not kind of gotten to the point where you can raise third-party capital, then you're probably not able to repay that note anyhow. So, some people fight hard to get the right to have this right to repayment in the future, but it's a practical matter. It's probably not something that they're really gonna need, or it's not gonna work for them. And then as you get a little bigger, you get what they call growth capital. And again, this is where you get a lot of buzzwords. You hear people use terms like Series C, Series A, Series B, etc. And these are not rules of the road. These are just kind of terms that people have come up with to identify kind of where in the process you might be. Series C is an early round, but it's a more either going to be going outside of your friends and family to high net worth individuals or family offices, or maybe angel investors or other kinds of institutional investors. Series A, again, that's similar, but you're just getting, now you're on the next round. Every round presumably gets a little bigger, maybe attracts a little bit more the institutional venture capital type funds or family office funds, things like that. And so the form of investment there is typically convertible preferred stock, which comes with it. I'll get you to that in a minute. Oh, you know what? So I'm going to go to this slide. We've already talked about what safes are and how they work, and what convertible notes are and how they work. So I think I can jump past this, and we can answer any questions if you have them. And again, here we talked about what common equity is, last to be paid in liquidation, but has the most upside. So the convertible preferred equity that most investors are going to be looking for out there is, it's an equity security. It's a stock, but it's senior to common stock, junior to whatever debt's on the books. So in terms of, if the company for some reason were liquidated, they would get paid after the company's debt or other payment obligations, but before the common equity. So they want to be senior to common because they want to be ahead of the founders, and they want the founders, again, as I said before, to be super motivated to run, to create as much value in the business as they can. Some of the tricks of the convertible preferred and why it's not used in earlier stages, or it's not, it's just not attractive to a much earlier stage business, is you need to do a valuation of the company. So, the question is, when you're talking to outside investors, is how much money are they going to invest, and what percentage of your business are they going to get for that money? So you need to, in that goal, determine based on the valuation of the business. And it's just, assuming it's still a high growth company that's not very far along in its life cycle, determining valuation is really an art, not a science. It's a negotiation. You're going to try to, based on, what you think are the prospects of the business and things like that, you're going to negotiate with your investor group as to what the value of the company is. So if they're looking to put $5 million in, is that, at a $10 million valuation or at a $50 million valuation? And that's going to drive what percentage of your business you're selling when you close that financing. So again, these are negotiations. You'll see terms like pre and post valuation. I'm not going to get into the details of those, but just be, most important there is when you're negotiating with investors, make sure you're all on the, very careful to make sure that you're all on the same page when you're using terms like pre and post valuation, so that you know exactly what the value is they're talking, that you and they are talking about the same value when you're talking about the valuation of the business. You'll see terms like fully diluted capitalization, and that just means that investors are going to look at your business and assume that all the options and other types of convertible notes or other things that may convert into equity in the future, they're going to assume that they've all been converted when they're doing the math to figure out what percentage of the business they're getting. So it's fully diluted. So that's all that means. Terms of a preferred, so the investor is going to take a preferred stock. They're going to want a preferred distribution, dividend or distribution, presumably, which means that stock's going to grow at some percentage rate annually. So they're going to want a 6% dividend. You're not going to pay it in cash because you won't have the cash, but that's going to grow the size of their preferred stock. And in the future, if they convert it into equity because you have some kind of a transaction that makes sense, they will get a larger piece of it by having that preferred return. That number might be 6%, something in that neighborhood. Again, subject to negotiation and depends on where you are in your life cycle and a number of other things. But the preferred return is part a liquidation preference, which means they're going to get paid before the common, as I mentioned, in the event that the company is liquidated for any reason. Sometimes they'll negotiate for more than the value of the preferred. They might, if it's a 1x liquidation preference, that means they get paid back there for their preferred plus the preferred return before you do. If it's a 1.5x, they actually get 1.5 times the amount that they've invested plus the distributions or dividends that have accumulated. So you typically want to stay with a 1 time and you want to negotiate for that, but you can see other things that investors will ask for. An investor will typically in a Series A or possibly in a Series C, that depends on, ask for board seat. Usually 1 seat, could be more, but it will never be a majority. So if they ask for 2 board seats, you might make sure you have 5 in total. You want the other board seats to be controlled by the founders so that you really have the ultimate decision-making authority, but your investors have a seat at the table and they're getting all the information that directors have and other things. And then they'll also want certain voting or veto rights, which means certain significant transactions and things that the company wants to do. They're going to require that their director on the board approve that. And if they don't, you can't do it. So they'll have some rights to prevent the company from doing certain things. They'll have a seat at the table. And then they'll want some certain transfer rights, which you see the term on here, drag along. That means if you're going to sell the business, that they may have some rights. Again, these get complicated as to how they actually negotiated, but they may have some rights to require you to sell your equity along with them if they, under certain circumstances. So they force a sale of the company and drag you along, or drag the other shareholders along. There are some other structures that they use to sort of protect their right to get some liquidity at some point. They often, don't want or can't agree to be, stay in your illiquid preferred stock indefinitely. So they will have some additional rights. Quickly, I'll go through the capital raising process. I think we're probably running a little short on time here. So, most important, I have this bullet here that says have your act together. You want to have a clear, succinct story and a mission. You probably, even early on, you want to have a kind of a one-page description of what you think the business is going to do, as well as probably a longer deck and something that's more complete. But you want to be able to very clearly and quickly explain to potential investors what it is your plan is, what your mission is. Where's the opportunity that you're exploiting? Is there a market out there for what you're trying to do? What's your plan? What's your advantage? Why you and not somebody else? All that sort of stuff. You really need to think that through. This is not legal advice here. This is, kind of common sense. But the better you can articulate and the more succinctly you can articulate what you're planning to do, why it's valuable, and how you're going to get there, the more you're going to get the ear of folks with money looking to invest. Because obviously, if you're out there ready to invest, there's lots of people that would like your money. So you need to be the one that gets their attention. On the other hand, you can't just take money from anybody. I mean, you can, but you want to be thoughtful about who it is. You want people coming into your business that can add more value than just money. So some expertise maybe, or some history in the industry. Again, not required, but in a perfect world, you want people coming to the table that when they're sitting on your board, they can really add a lot of value beyond, just the money that they've brought. Again, what are you offering them? Early rounds are easier. Use these safes, convertible notes. There's something called NVCA, which is the National Venture Capital Association, and there are documents for these types of investments that are out there, that are forms that a lot of people use. There's very little negotiation necessary. That become very efficient ways to close on these financings from a legal documentation standpoint. As you get later on and the rounds get more complex, there's more rights for the investors. There will be more negotiation involved, and it won't be quite as plug and play. But that's okay. That's a good problem to have. That means you've gotten through a couple of rounds of financing already. And the other thing you have to be careful about is if you're doing a bunch of rounds of financing, again, this is push and pull of you want to raise as much money as you can, and you need to do it when you need to do it. But you also want to be, if you have the opportunity to be thoughtful about, what it is you're issuing and how it affects your prior rounds and things like that, that will be helpful, because it's not unusual that you get to a round of financing and you've already got a number of other investors and with different types of securities and different types of rights. And now you've got a multitude of people you need to negotiate with, not just your new investors, but you need to negotiate with your old investors because they have the rights to approve this deal. So you have, if you have to get everybody's approval to do the next financing, you really need the money, you're at their will, and you're in a place where you can be vulnerable to having to give concessions to even some of your existing investors, make changes in their terms, give them more rights, things like that, just to get the new deal done. So again, hard to really manage that, but if you can give it some thought along the way, that is always helpful. So closing thoughts, like most things, early preparation is best. If you give yourself a chance to make decisions without undue pressure. So the more again, things are moving fast. You kind of take what you can get when you can get it often. So it's not always easy to do this, but to the extent you have any time or any way to give thought to what you're doing, and the long-term implications, obviously that is better. And get experienced advisors to help you as early in the process as you can afford. Again, the push and pull, you don't want to spend too much money, but you also don't want to set yourself up in a way that's going to cost you a lot more down the road. So have a plan and a budget for getting advisors in to help you. And a lot of advisors, if you look like you really have know what you're doing and you've really got your act together, we'll be happy to get involved and help you early on at significant discounted rates, and hopefully maybe make that back later when you start doing some more work down the road. So try not to hurt yourself by saving a few bucks early on. And I think that's the last of my slides. So I'm going to turn it back to Gwen, and happy to answer any questions that come up.
Ken, thank you so much. Incredibly informative. I know the teams will probably need to revisit your presentation to gather all of the information and details. In the meantime, we have a couple of questions that have come through. When you sell additional shares or equity, what happens to the equity of the existing shareholders?
Well, nothing happens to it except you get, I'm going to use the term dilution. You get diluted. Well, there's a lot of ways to answer that. So let's assuming the new equity doesn't have a lot of rights that you don't have. So if the new equity is let's say you have common stock and you issue preferred stock with a bunch of rights that the common stockholders don't have, then the implication is that these people are now senior to you, and but that doesn't really affect your ownership. So again, the simplest thing is that you're just going to get diluted. So if there are 100 shares out there of the company and you own 10 of them, that's a 10% interest in the company. And if they issue another, 100 shares to somebody else, or another, now you own 10 shares out of 200. So now you own 5%. So yes, you've been diluted. Hopefully, you own 5% of a much more valuable company because the company got a lot of value for issuing those shares. Either they got money in or they used them to buy a company or something of value, but your ownership percentage went down from 10 to 5, but hopefully that 5% is in a 5% of a much more valuable entity. But otherwise, typically there shouldn't really be any changes to the stock that's already out there.
Okay, great. Since we have so many teams from around the world, if we're not setting up a company in the US, what should we be looking for? What forms will work?
Well, I should have mentioned this early on. I meant to, and I think I kind of skipped over it, maybe in the small print at the front of the, I'm not sure. But I work in the US. My expertise is around American companies. In fact, state by state they vary, but for the most part they're similar enough that we I can comment on them. I think for non-US businesses, obviously you need to get somebody locally who's familiar with the particulars, but most countries do have business entities that offer limited liability and are commonly used in the business, whether it's startups or just as operating businesses. I don't have any particular expertise to lend to this, in terms of except to say that every just like every state's different, every country's different. They're going to have their own rules, their own nomenclature. So you really do need to kind of look into the particulars. My sense is that probably, there's a lot of similarities to what I discussed here, but I can't really comment beyond that.
I would imagine this is the case again here, but I wonder if there's anything else you can add in that we need limited liability for shareholders no matter the location of the company. Are there corporate forms in other countries that you're familiar with that are same to corporation and LLC that allow this?
I mean, the answer is yes. But again, it'll vary from country to country, and I assume every country that we're talking about has this type of business entity. I mean, there will be wrinkles in it that are different than what we have, and I can't really speak to it, but I've done a number of work with UK companies, for example, and they use a little different nomenclature. They call them limiteds instead of incs, but you know, they're kind of got most of the same characteristics as the American entities that we've been talking about. So you know, I think it's the same answers. You really have to kind of look at the specifics of the country that you're looking to organize in. The other thing is, if you're, you know, even if you're not a U.S. resident or U.S. citizen, you can organize a corporation in the States and you can own it. And if, you know, if you were to organize a business and it's going to grow and you're looking for investors in the United States, they're going to be primarily going to want to see that it's a U.S. entity they're investing in, just because they will be more familiar with the form of entity, the laws that go around it, you know, how they work as far as being an investor shareholder. So, you know, it's fairly typical that, you know, overseas owners would incorporate a U.S. entity, you know, to operate a U.S. business if they're looking for investors locally.
Let's see. Can we set up a company on our own, or do we need an attorney? And sorry, just to expand on that, excuse me, if we do need an attorney, what should we really look for in that corporate attorney to help?
Well, I guess I'd break it into two things. Can you set up a company on your own without an attorney? Absolutely. You can go to LegalZoom and lots of other, you know, those types of service providers, and you can create an entity in whatever state you want, and they know how to do that and have basic paperwork that, you know, for actually creating the business, it's fine. But if you're talking about a business that you expect to grow and to turn into you know, something that's going to get outside investors and maybe, you know, have a bigger footprint, you know, so if you're interested in opening a single coffee shop in New York City and you want to start a business, you can go to LegalZoom or something like that and have them create an LLC for you, and you can operate your business. It's pretty straightforward. But if you're gonna organize an aerospace business that you're hoping will you know, become nationwide or international and get a bunch of institutional investors interested in you and that sort of thing, probably makes more sense. In fact, definitely makes more sense to have some professional help, at least in terms of setting it up in a way, because that you're not going to have to redo it again once some investors or other shareholders kind of come in and want to join you. So, in terms of looking for an attorney, again, it's pretty easy to just set up a business, but I think if you really are looking down the road and you think you've got something that's gonna have some legs, it does make sense to really look for somebody who has experience representing startup businesses through their growth phase and through their financing phase, and at least so they can, even in the very early stages of setup, they know kind of the, you know, mistakes not to make and things to do that will, you know, serve you well as you grow. And like I said, that may cost a little bit more, may cost a lot more, but you can typically find people that will, you know, do that for you at some discounted rate if they think you look like you've kind of done your work and you have a real plan, and there are ways to get that done pretty inexpensive. The real cost for lawyers and things tends to come down the road when you're negotiating with institutional investors like VCs. Things get more complicated, you know, and that's where you're going to probably end up paying more to your lawyers. But frankly, if you do pay more to your lawyers, it's because you got a 9 or 10 figure check coming in from the investors when the deal's done. So, you know, that's probably worth the cost too.
And thank you so much for your time. We are at the hour now. We really appreciate all the expertise you've offered. To our teams, as a reminder, Stage 2 registration is currently open, and we encourage you to review all of the documents that are required in order to become an official team for Stage 2. You will find them all on the website at herox.com/GoAERO. If you have any questions regarding Ken's presentation or anything regarding stage 2 registration, please contact us at info@goaeroprize.com. Ken, thank you so much.
My pleasure, Glenn.
Take care. Bye-bye.